Hello everyone, welcome to Drishti IAS. You're watching the Current Affairs Plus series and the topic of today's discussion is Anti-Defection Law. So without further ado, let's first look at why this law has been making the headlines. The Honorable Supreme Court of India has given a 21-day deadline to the Speaker of the Telangana Legislative Assembly to decide the disqualification petitions of two MLAs from the Bharat Rashtra Samiti who have shifted their allegiance to the ruling Congress party. And the Supreme Court has also said that not doing so is going to invite contempt proceedings. Now, with this background in mind, let's look at the questions that have been asked by the UPSC in previous years. Prelims 2022 had asked a question with reference to anti-defection law in India. Consider the following statements, and a couple of statements have been given. But before we try and understand these statements, let's first understand the anti-defection law. So the anti-defection law has one purpose: to prevent political defection for personal gains, meaning that an MP or an MLA cannot shift allegiance to another party for money or for power without being disqualified. Earlier, what used to happen was that MPs and MLAs would frequently shift their allegiance to different political parties, and this would lead to political instability. It would also lead to frequent falling of the government. And of course, very importantly, it also led to the betrayal of voters' trust. So with these issues in mind, the Anti-Defection Law was enacted by the 52nd Amendment Act of the Constitution in 1985, and this added the 10th schedule to our Constitution. Meaning, the idea was to provide political stability, to prevent frequent toppling of the government, and also to respect and dignify the voters' sentiments. Also, there were various grounds of disqualification that were mentioned. So, the first ground was voluntary resignation. If an MP or an MLA voluntarily resigns from the political party, then they are subject to disqualification. Now, this resignation need not be an announcement or a formal declaration. It can also be inferred from the actions of the concerned MLA or MP, which leads us to the second ground of disqualification under the law. The second ground says if an MP or an MLA does not follow party instructions, meaning that if the party whip has asked you to vote in favor of a motion and you decide to vote against it, or vice versa, then you are subject to disqualification. The third comes with independent members. If an independent member of the Parliament or the Legislative Assembly joins a political party after their election, then they are again liable to be disqualified. And finally, when a nominated member joins a political party after 6 months, then they can be disqualified under the Anti-Defection Law, meaning that they can join a political party within 6 months of their nomination to the Parliament or the Legislative Assembly. With this background in mind, now let's look at the questions. The statements. 1. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. So this is incorrect, because in fact the law specifies that a nominated legislator can in fact join any political party within 6 months. But if he or she does so after 6 months of being appointed to the House, he or she is going to be or likely to be disqualified. Now this is incorrect, so we can remove option A and C. The second statement says the law does not provide any time frame within which the presiding officer has to decide a defection case. This is absolutely accurate. The law has not provided any time frame within which the speaker has to, or the presiding officer has to decide a defection case. And this, student, is one of the major criticisms, foremost criticisms of the anti-defection law as it is in its current stage. So, the correct answer is B only, which is option number 2. Next question says, consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Union Ministers shall be final. So this statement says that if there is a question of disqualification of any member of the House of the People, meaning any member of the Lok Sabha, then the President's decision in concurrence with the opinion of the Council of Ministers shall be final. However, this statement is factually incorrect, because who decides disqualification? The disqualification is decided by the presiding officer of the House. So in case of the House of the People or Lok Sabha, it happens to be the Speaker, and in case of the Rajya Sabha, it happens to be the Chairman of the Rajya Sabha. So also for the state legislative assemblies and councils. Hence, this statement is inaccurate. The second statement says there is no mention of the word political party in the Constitution of India. Again, an incorrect statement, because the word political party has been mentioned various times in the 10th schedule, which introduced the anti-defection law, which was introduced by the anti-defection law. So the term political party has been used multiple times. Therefore, this statement again is incorrect, and our correct answer becomes option D, which is neither 1 nor 2. The next statement, the next question was asked in UPSC 2014. Which one of the following schedule of the Constitution of India contains provisions regarding anti-defection? The answer is very straightforward, the 10th schedule of the Constitution. Therefore, option D is the correct answer, and this we have discussed in sufficient details in the preceding questions. Now there is something about the anti-defection law. We have discussed this. What is important here to be discussed is the 91st Constitutional Amendment Act of 2003. What happened before that was that the law allowed for split as well as for merger. Now, in case of a split, if 1/3 members of any political party separated from that political party, they were considered to be a valid faction, a separate entity. Now, this led to more defections instead of political stability. This was leading to more defections, and the purpose of the law was getting defeated. Hence, with this amendment of the 91st Constitutional Amendment Act of 2003, the provision containing split was omitted, and that of merger alone was retained. Meaning that if 2/3 members of a political party agree to merge with another party, then this merger would be considered as valid, and these members would not be subject to disqualification. Now, this aimed at maintaining some sort of a political stability and preventing various defections. Now, the objectives of the law we have read in previous explanations to various questions. Even the grounds for disqualification, voluntary giving up, abstaining from voting, basically not following the party's instructions, if an independently elected member joins a political party, or if a nominated member joins a political party after 6 months of becoming a legislator. All of this has been discussed. Now, there are also certain exceptions to disqualification. One is that a party can merge with another if 2/3 of the legislators agree, with no disqualification for those who merge or stay. So, this is the exception to the anti-defection law, And this exception was retained even in the 91st Constitutional Amendment Act of 2003, also discussed sufficiently earlier. Now, no disqualification for speaker, chairman or deputy chairman resigning from the party to remain neutral. Now, there is a provision that provides that if the presiding officer of the House decides to resign from their political party in order to maintain neutrality and non-partisanship in the House, then this voluntary resignation is not going to disqualify them. So, this is also another exception to the rule. Now, the role of presiding officer, we have discussed that the disqualification cases are decided by the presiding officer, which is speaker in case of the Lok Sabha as well as the state legislative assemblies, and the chairman in case of Rajya Sabha and legislative councils of the state wherever applicable. But this decision is subject to judicial scrutiny in the form of judicial review. However, the courts can intervene only after a decision is made. So, this is the caveat. Now, there are also various criticisms that the law has invited. The first one was what we discussed in the question, that no time limit has been specified in the law for the speaker to decide, meaning that the speaker can keep on delaying decisions without inviting any penalty. So, this is one problem. And of course, this problem has been criticized by courts because this is defeating the very purpose of the law. The second is that the speakers often belong to the ruling party, and then there is a deliberate delay in deciding the disqualification petition of members belonging to the same political party, which again defeats the entire purpose for which the act was enacted. It curbs dissent by limiting legislators' freedom to vote as per their conscience. Naturally, it gives limited room for exercising a person's own conscience because you have to follow the party's instructions. Otherwise, you may get disqualified. And finally, it also discourages intra-party democracy because this means that the party leadership can actually suppress any kind of internal criticism or dissent. Now, what is the Supreme Court's stance on anti-defection? Three very important laws have been mentioned here. The first is Padi Kaushik Reddy versus State of Telangana, and this is also the most recent case. Now, in this case, the Supreme Court urged parliamentary reforms for fair and timely adjudication of anti-defection disqualification petitions. So here the Supreme Court has urged some sort of a reforms that should be brought so that there is a timely adjudication of disqualification petitions under the Anti-Defection Law. The second case in consideration is Kaisham Meghachandra Singh versus the Honorable Speaker of Manipur Legislative Assembly, a case from 2022. Here again, the court instructed or rather recommended that such cases of disqualification must be decided within 3 months and that an independent tribunal can also be set up to decide such disqualification cases. So, this was mentioned by the Kaisham Meghachandra Singh case. The third and the most popularly known one is the Kihoto Holohan versus Zakilu 1992 case, which of course reasserted that the decision of the presiding officer is subject to judicial review. So, these are the three important cases that you ought to remember that are very important, particularly from your prelims point of view. And with this, we have covered today's topic in detail. Now, this is also a question that I have brought for you that you ought to attempt with the information that we have discussed in detail in this video. If you like today's discussion, please like, share and subscribe and hit that bell icon. And also, please send me your answers in the comment section. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.